This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about Chutzpah, which is a Yiddish term meaning totally unmitigated gall, where a fraud perpetrator tries to use the United States District Court to avoid paying a judgment of $45,657,401.01 against a fraudster who, after moving his money around and getting caught at it, tries to protect his cash through the bankruptcy system. And the United States District Court, after reviewing the matter, refused to allow procedural rules to enable a fraud perpetrator, Mr. Lupolover, to manipulate the federal court to avoid paying his judgment. Before the United States District Court, Eastern District of New York, was a motion of non-debtor respondents Michael Lupolover and NJTM Ventures, LLC, seeking reconsideration of the court's July 29, 2024 order establishing a temporary restraining order. In Allstate Insurance Company versus Mirvis et al., a September 26, 2024 decision, the court was compelled to continue jurisdiction of an order of 2008 motion by the Plaintiff Allstate Insurance Company after Michael Lupolover's father, Mark Lupolover, and numerous other defendants were found to be involved in a massive health insurance fraud scheme carried out by the defendants between 1995 and 2008. In May of 2015, 9 years ago, Allstate obtained a default judgment against Lupolover and other defendants jointly and severally in the amount of $45,657,401. And after the judgment, Lupolover continued sustained efforts to evade enforcement of the $45 million judgment. As a result, the court ordered the plaintiff to conduct ex parte discovery to identify and locate Lupolover's assets. To date, Lupolover has not paid anything toward the judgment. On May 31, 2024, plaintiff filed an ex parte motion for a temporary restraining order to show cause and or preliminary injunction as to Lupolover and the non-debtor respondents, which included Lupolover's wife and non-movement Michael Lupolover, as well as 3 corporate entities. Plaintiff sought a TRO freezing Lupolover's and the non-debtor respondents' assets. Plaintiff presented evidence that Lupolover and his family had engaged in a years-long campaign to dissipate and conceal Lupolover's assets, in part via 3 corporate entities, and evade the $45 million judgment against him. On June 4, 2024, the court granted the requested TRO and scheduled a show cause hearing for June 7 of 2024. On June 6, 2024, the non-debtor respondents requested an adjournment of the hearing for about 1 month to allow the sufficient time for discovery and briefing. The request stated, quote, "The non-debtor respondents agree that the other terms of the order, including but not limited to temporary restraining order restrictions, which shall remain in place until the conclusion of the to-be-scheduled new hearing date and the determination of plaintiff's order to show cause, would remain in effect during any adjournment." On July 3, 2024, counsel for the non-debtor respondents notified the court that Lupolover had filed for bankruptcy that day and requested an automatic stay pursuant to Section 362 of the Bankruptcy Code. On July 29, 2024, via docket order, the court imposed the Section 362 stay and denied the non-debtor respondent's request to lift the TRO because of the stay. The court denied the request and stated an, quote, action to recover fraudulently transferred property is properly regarded as undertaken to recover a claim against the debtor and subject to the automatic stay pursuant to Section 362A1. Even when a creditor seeks to have fraudulently conveyed property returned to the debtor transferor's estate, the creditor's action against the transferee remains an attempt to recover its claims against the debtor if indirectly and is stayed. Accordingly, the action is stayed as to judgment debtor Mark Lupolover and the non-debtor respondents pending the resolution of judgment debtor's bankruptcy proceedings, and the hearing scheduled for July 31, 2024 was adjourned sine die. The court shall modify the TRO to permit judgment debtor to comply with the bankruptcy court's orders, but otherwise the TRO shall remain in effect pending the resolution of judgment debtor's bankruptcy proceedings. The court finds that permitting the TRO to remain in effect, particularly as to the non-debtor respondent's assets, best furthers the public policy considerations behind the automatic stay provisions, which is intended to maintain the status quo. Particularly in the context of this case, where plaintiff has put forth pages and pages of evidence indicating that Lupolover and the non-debtor respondents are working together to evade a multi-million-dollar judgment, this sequence of events reeks of gamesmanship. The non-debtor respondents seek to use the automatic stay provision as both a sword and a shield by arguing that the provision precludes the court from adjudicating plaintiff's motion for a preliminary injunction and simultaneously requires the court to lift the TRO on the non-debtor respondents' assets, which notably are not part of the bankruptcy estate. But the non-debtor respondents cannot have their cake and eat it too. The U.S. District Court concluded, quote, this court will not permit Lupolover and the non-debtor respondents to improperly manipulate the federal procedure rules to enable Lupolover to avoid paying the judgment issued in this case. Accordingly, the court denied the non-debtor respondents' motion for reconsideration, and their assets are still held in the control of the court. In my opinion, people who commit fraud have chutzpah, Yiddish for unmitigated gall, and even when they lose and are faced with a final judgment more than $45 million, they continue to have sufficient funds to hire lawyers to use the federal courts to avoid paying the judgment, including trying to use the bankruptcy courts to hold off the judgment creditor Allstate for many years, resisting the purpose for which the federal courts and the bankruptcy courts were created, and avoiding legitimate judgments of the court so that their fraud can succeed. All I can say is well done, Pamela K. Chen, United States District Court. And hopefully the bankruptcy court will see through the fraud as well. This video is adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 4,900 blog postings. You can also ask to subscribe for a very small fee to my Substack publication so that you can get further detailed information about insurance claims, insurance law, and insurance fraud. And I'd appreciate it if you tell your friends and colleagues about this blog and the videos and the Substack publication so that they too can subscribe. Thank you for your attention.